my lord. I think I've probably said enough on the revocation issue, and some of the issues on construction come up again in infringement, but I don't think it's exactly the same. So I think propose to move straight on to that topic. The points in response to my learned friend, perhaps they could wait for a short reply, and I'll deal with those then. The infringement part of the decision is also relatively self-contained and comes in after the revocation section, and it's at page 261 of the core bundle at 20. I just wanted to show you the basic findings and logic of the judgment in that respect, and what we say is wrong with it. On this appeal, we got permission from the judge, and we have picking it up at 295. Infringement and honest concurrent use are dealt with together. This was before my Lord Justice Arnold's judgment in the Musmatch case. I think both parties have made a certain amount of submissions in relation to that, because our first skeletons were filed before that, and then we both had another go after that. The judge considered section 10.1 because it was pleaded, and set out the basic criteria, and held that the marks, at least the word-only marks of EasyGroup, EasyOffice versus EasyOffices used by Nuclei, were almost identical, but not identical. And then, of course, there's the passage of reasoning that I took you to on the question of revocation, which was the analysis of construction. It's not exactly the same question, because, of course, the facts that are being compared relating to Nuclei's site to the specification are not exactly the same as EasyGroup's site. But
so you showed us how the mark was used by your clients.
Yes.
How was the mark used by Nuclei?
Yes.
In the manner complained of?
That is
the
the
sign.
yes. Would my lord like to see that? I've got that's in the bundles. It's it is tab 23 of SB1. Now, we have quite a long period of different types of signs being used, but
well, the logos changed, but
logos have changed. But
I don't think anybody's saying that the logos are terribly significant.
The content, well, no, we do. There is a point on the logos, but so far as to answer my lord's question, which I think is what sort of service was being provided.
Yes.
That is really better shown by the later, just because there's a lot of info missing on the earlier ones, and it was sort of seemed to be quite a different business model, was the evidence at trial. But if you look at, let us say, front page of this, which is I think the most, so this, we've got the last two iterations. So there's one in 2015. That is page 235. Front page, sorry, 234. EasyOffices. I think that's the front page of it. A picture of a woman holding a mobile phone. Availability, pricing, latest offers, and then over the page, our most popular.
Is that the front page?
Well, the reason I thought that was because there's an email that talks about it, but
I mean, I'm not saying you're wrong. I just want to be sure.
Well, that's right. It isn't completely clear. Perhaps if we look at 237, might be an example of another one. Find a service office in. This was the material at trial, so I think that was obviously put in by defendants, not us. but you get an idea of what it is. Perhaps if you look at 245, which is back in 2003, that's sort of out of the chronology, but you can see sort of the way that the website was presenting itself then.
Okay.
So the judge obviously was considering that.
Just give me a moment to look.
Yes, of course.
Right.
I should make it clear that those are later versions, and we've looked at a very early version, and there are versions in between.
Okay.
So the judge said at 299 that the nuclear office business does not fall within the specifications of 528A and B, 8A and EU 509. The closest that the marks come to Nuclei's business are the specifications for hire and rental of temporary office space, but it doesn't itself hire and rent office space. So this was now being applied to that, to those facts. And the brokerage of office rental, notable, the judge calls it the brokerage of office rental, is of course, as I've already found, related to the activity of hiring, but that's not sufficient to engage the provisions of 10.1. And the judge finds that is not the sort of core or substance of those services. And at 301, the same is true of the services in the present case. A service consisting of brokerage, not an ancillary feature of the rental office space, a different service entirely. Yes, sorry, different service entirely. Mr. Ballage argued that anyone visiting the EasyOffices website would understand that this was a service of office rental. I disagree. While the EasyOffices site advertises offices to rent, nothing on the website indicates that EasyOffices itself rents or hires offices. Quite the contrary, that's emphasised by the information given on the heading about us. We created EasyOffices for one simple reason: to make it easier for people to find great places.
The website makes clear that it's
did I miss the line? Sorry.
Yes, I think back.
Oh, back earlier.
Quite the contrary. The website makes clear.
Quite the contrary. The website makes clear that it is a portal to enable people to find office space. That's emphasised by the information given under the heading about us. We created EasyOffices for one simple reason: to make it easier for people to find great places to work, to gather every square foot of workspace in the country, and put it all under one roof. So,
Do we have the
specific
screenshot that's a reference to?
I was just about to ask myself the same question. I'm reminded to take you to page 254 of this particular tab as being the current page. I understand it. That's the current logo anyway, so it's pretty up to date. Office space and serviced offices in London. Our London advisors are here to help you with availability prices and latest offices. And there are pictures. So there is a point on the advertising that I just wanted to mention, which of course and this was a discussion before the judge at trial, there's a difference between advertising services per se and the act of advertising carried out in relation to a product or service. It's the difference between Saatchi and Saatchi or any advertising agency and one who is doing as this company is doing. And we say that's quite an important point in this case, that there is an acknowledgement of advertising, and we actually rely on the defendants.
Sorry, before we get into the advertising question,
yes.
Can I understand how you put your case on 254? It's not exactly what the judge seems to be quoting
On
from.
254.
So, office space and serviced offices in London, and then we've got London City serviced offices from £99, Dockland service offices from £158, and get a quote for London, send me my quote. So You say this is hire, stroke rental of office space, do you?
Well, we say it's the advertising of hire or rental of office space. Yes, it's use in relation to that. We do say that. I think the page is this the page in question that you want to show me? Yeah. Just a moment. So, but in answer to the question whether the judge's specific page in mind is here.
I think it's page 261.
My lord's found it, has he? I'm grateful. Yes, there's the blurb about creating easy offices for one simple reason, to make it easier. Yeah, yes. But the question here is whether there is whether this is use in relation to the specified services, and there are two further documents that I wanted to show my lords in that regard. First of them is the amended particulars of claim and the pleaded case in response. So for that, that's the call bundle. So the call bundle tab 29. I hope not to look too deeply at the pleadings on this, but it's just very important to see exactly what the position of the defendant was. So the position of the claimant was in page 301 over to page 302. This was use in relation to, the marks that were relied upon were rental of offices, hire of temporary office space for the first two marks, and then for the third, there were a number of services, including advertising services, that happens, but rental of offices and over the page at 4.3, information and consultancy services for all the aforesaid. Now, the amended defence and counterclaim, which is the next tab on page 2, states at paragraph 8, the first defendant, that's Nuclei, has carried on business in advertising the rental of serviced office space and providing advice in relation to the selection of serviced office space to rent. And that's really been the case from the beginning. There's been some amendment as proceedings have gone on. The reply and defence to counterclaim, there was a Part 18 request relating to the bits of the specification.
So let me be crystal clear. Do I understand that your submission quite simply is that paragraph 8 is an admission?
No, because if you want to go to the rest of the pleading, see what we omitted use
Sorry,
in
the
relation
question
to.
directed to me or to you. The position is that there is a concession, that is advertising, yes, of rental of office space. It says what it says. It is an
Yeah,
admission.
you're relying upon that as an admission.
Yes.
Yeah.
I will.
All right. The position then gets developed in the pleadings a little bit, and it becomes there's a question about the use that's been made, and that is dealt with by way of the Part 18 request. I mean, I'm not quite sure how this pleading point is going to develop, but it would obviously be helpful for me to know before I opened this. But
Well,
we have
you're
asked,
the one at the moment who is relying upon an admission.
Yeah.
So it's for you to make your case.
No, it's true, my lord. But the point is, there's been a bit of correspondence in the background about narrowing of the case that we've quizzed them about, and we just never learned what the answer is. And I'm now dealing with the point, and I'm still not finding out. But whatever. The position is pretty clearly pleaded. We say it. Bundle pay tab 33, 373, page 373. There is a Part 18 response by us. And if you look at the bottom of the page, we're talking about the period 2007 to 2010. We talk about the evidence of Mr. Smith, and that evidence was before the judge, who explained that the claimant's business has operated until 2009 on the following different levels: operating serviced offices, brokerage of serviced offices, provided on a white label basis, offering and managing franchisees. So we can delete the third of those that didn't arise in the appeal. And then that is continued over the page, 2010 to 2011.
I'm sorry, Mr. Malinich, I'm baffled. What on earth has this got to do with Nuclei's use? This is your own clients.
It's our own use, but there seems to be there seemed to have been some point about us narrowing the infringement case. And what happened was, with this document, we served the particulars of we sent a copy of the particulars of claim that you can see there. And the case was, this put on the broader
The
base.
request is all about genuine use.
Yes, exactly. But, well, perhaps I can deal with it in reply, because I'm sort of anticipating something being said about this without quite knowing what it is being said.
Well, there's no point in doing that.
Yeah.
When a document that on its face is all about genuine use and nothing to do with infringement, Ms. Van Egan wants to say that that's something to do with infringement, that'll be for him to explain how he gets that out of the document in due course.
Just to make it clear from our perspective, we've always said that the use that's been made supports the paragraph 4 particulars of the amended particulars of claim that I've shown you, and that is also what is relied upon for the purposes of infringement.
I'm sorry, Mr. Malinich. You're again deeply confusing me. I'm sorry if I'm missing some subtle point here. But I thought you had now moved on to the question of infringement, which is the question of how the defendants have used the sign complained of.
Yes.
That is an entirely different issue to the issue of non-use of your trademark, albeit that there is a common sub-issue as to construction of services. Yes.
My Lord has encapsulated the position. I will move on. I don't need to address you. The next part of the analysis in the judgment is to, having found that there's no double identity, the judge finds, of course, there's no single identity. In other words, there's no identity of services or identity of marks. So she considers the entire case under section 10.2, which is the claim for infringement based upon...
I thought you submitted in your skeleton argument that she had not decided the issue of identicality of mark and sign.
Well...
Because she doesn't refer to LTJ.
Yeah.
She says almost identical, but the dispositive paragraph is expressed purely by reference to the services.
Exactly right. That my Lord has it exactly. I'm sort of more staying with the summary of the judgment before I get into the detailed criticisms. That is a detailed criticism. The judge then deals with 10.2. She summarises the position based upon the familiar factors, which she takes as it happens, paragraph 306, from my Lord's Arnold's W3 decision, and those are well established. And then there's a curious paragraph, 307, because, and that has to be read in the context of the whole judgment, because what had happened was the judge had held that all but our coloured EasyGroup marks, EasyOffice marks, would be liable to be prevented in passing off. And the judge is obviously alive to the point that there's a potential inconsistency between a finding of non-infringement in relation to the defendant's marks, when the claimant's marks relied upon are said to be deceptive of the defendant's goodwill. And there's a passage there about the distinction between the test of validity in passing off and the test of infringement, which, without, for the moment, dwelling on it, I'll come back to. Then we come to the key part of the judge's reasoning, and that is that this is a case in which an absence of evidence of confusion was telling, was, we say, determinative, given that all the other factors seem to point in the other direction. And we say that there's an error in relation to that. When it comes to honest concurrent use, to be fair to the judge, she was reaching a decision in a state of some legal uncertainty because I think my Lord, or Justice Arnold, had in the W3 case indicated that it was ripe for further, potentially ripe for a reference and further decision, and then in the Musmatch case has explored and explained in our submission the law on this. So the key sort of analysis and findings then get, that's the sort of previous analysis, pre-analysis. Then we come to 316, where the judge holds that there is, they're almost identical on the word marks. The black and white figurative marks are also visually quite similar to some of the logos used by Nuclei, in the use of a white font on a dark rectangular background. That was incidentally one of the ones we were looking at a moment ago, and that would point towards confusion. And then holds that the, let's say, the coloured mark, so that's the third mark in the 528A series, and the 376 mark are not confusingly similar because they, the nuclei signs are not confusingly similar to those because they're very different. He considers distinctiveness, and then 319 considers similarity of services. A small point on that, which is that we would remark upon, which is there's no application of the canon principles or a principled approach to assessing similarity of services. But it doesn't probably matter because in this part of the judgment, they're held to be closely related. There's a bit of a strange movement from the judge, we would say, because earlier they were entirely different in the context of assessing whether they fell within the specification and revocation. But one can potentially understand that there would be a different approach there. So that's not a specific ground of appeal, but there doesn't seem to be a very clear focus on the degree of similarity in services, and we do take a point on that. So we do take a point on the extent to which the judge applied the interdependence principle. And the judge went very long on the issue of evidence of actual confusion. That's not even one of the factors in the W3 Specsavers list of factors, USS. It might be relevant in one particular case, particularly the presence of instances of confusion rather than the absence, but it is an evidential point, and we say much more important than that was the judge's analysis of the basic requirements of a likelihood of confusion. Although we do also attack the finding that the absence of confusion in this case, or absence of evidence, led to any reasonable inferences. So the finding here is that there was an absence of evidence of confusion, that one would have expected there to be some, that the businesses were large enough and concurrently trading for long enough for such confusion to come to light, and the judge found that to be determinative, really, in the overall question. Then when it came to honest concurrent use, the judge held that the circumstances give rise to a strong case of honest concurrent use, and I'll address you separately on that. So, the starting point really is to consider the issue of double identity. As my Lord Justice Arnold put to me a moment ago, we do criticise the judge for not actually reaching a finding or not providing any reasoning that's capable of being understood sufficiently for the purposes of an appeal, perhaps. All the judge did, my learned friend says, well, it's very brief reasoning, but it's there. We disagree with that because all the judge says is that they're almost identical. But all that does is engage the principle of double identity or not, because we know that there is this principle that has come from the European Court in LTJ diffusion, it's also covered in the Reed case, that marks that are nearly identical may be identical. And that's just, so there has to be, that's the starting point for the analysis. That is not the analysis itself. You're not going to regard Nuclei and EasyOffICE as double identity cases. It's going to be a case where they are almost identical. And it seems that the judge thought that was sufficient to dismiss the case on double identity. The case law from the European Court is, perhaps surprisingly, does allow for cases of almost identicality to be regarded as identical, depending on the nature of the consumer, imperfect recollection, and so on and so forth. And the case I have in mind, of course, is the LTJ case, although it's also discussed in Reed. It's bundle 6. European authorities, one moment. It might have been, actually I think this one was pulled because it was all covered in Reed anyway, so in that case that's a bad reference. So I will take you, my lords, to Reed instead. Bundle 2, tab 21. This case was interesting on a lot of different points, but the specific point was the point about double identity. If you, it's a lot of sidelining here, but if you pick it up at page 519, to bring a case within Article 51A, the proprietor must show two things: use of a sign which is identical, use for goods and services which are identical. So is this a case of identical sign? Now, Lord Justice Jacob then deals with the LTJ. I wonder if Wells could just read through briefly.
To where?
I think down to, there's an indented passage over the page, which is probably all you need for the present purposes. So the indented passage below 24. But then perhaps Lord Justice Jacobs' remarks on 25. And so clearly this is for marks that are in the, let me put it this way, EasyOffice and EasyOffices are in this sort of territory. The question is whether they are identical or not. The comments by Lord Justice Jacob, the guidance is opaque. On the one hand, the criterion of identity must be interpreted strictly. On the other, you take into account imperfect picture that a notional construct, the average consumer, keeps in their mind. And there's the sort of policy consideration that clearly the court did not intend to stretch the meaning of identity too far, all of which we accept. And this is a case where EasyOffice and EasyOffices are the same word, but either plural form or possessive form. Where services are concerned, it is very common for consumers to refer to them in plural form or possessive form without distinction. And the examples I give in this skeleton are, somebody says to you, I'm off to Sainsbury's to get a pint of milk. Whether they said Sainsbury's to you or Sainsbury to you would be probably something you would not remember. And equally, if they sent you an email writing it down, because they are interchangeable, because services are prone to be provided by groups of people. I went to see my lawyers, I went to see my lawyer, my accountants, my accountant, and that is the same level of difference, we say, as between EasyOffice and EasyOffices. It's a matter of impression to some extent, but the judge didn't give any consideration to the principle or to the submissions. And I was maybe wondering, usually 10.1 doesn't matter very much because you've got 10.2, you've got likelihood of confusion. You can say they're highly similar. If they're not identical, they're highly similar. But the significance in this case, of course, is if I had succeeded on 10.1 and succeeded on if I'd succeeded on identity of services and succeeded on identity of marks, well then, of course, there would be no relevance to the absence of evidence of confusion because a likelihood of confusion would be presumed.
Well, except it would come in under honest concurrent use.
It would come in that way.
What it does is it alters the burden of proof.
Alters the burden of proof
as to likelihood of confusion.
Yeah, absolutely. And gives, that we say comes in under honest concurrent use anyway, murdered friend. That's why the honest concurrent use, not to ruin the bond, but that's why we say the honest concurrent use was miles from being established in this case. But we'll come back to that. But so far as the 10.1 point is concerned, if this were a 10.1 case, it should have been established on the facts. I've already addressed you on the services. This was a use in relation to identical services as we construe it. And therefore, we're right. If we're wrong on either of those two things, then the judge was necessarily wrong. Sorry, if we are right on either of those two things, so if there's single identity, either identity of services or identity of marks, then as a matter of logic, the judge must have erred when it came to the overall analysis because he was providing a double similarity, not an identity versus a similarity, which is a different mechanism, so to speak.
Now, can I ask you a question on the services limb? I mean, I don't want to go over all the construction issues again, but I think that one of the points you were making earlier was that, again, the judge doesn't deal separately with information in relation to. Have I got that correct?
Yes, you have got that correct. It's also the position under the infringement case. So, first of all, the mark gets revoked for EU 376. This is only to do with EU 376.
Yes.
That gets revoked as if it's never been used. And then when it comes to the infringement case, even though it appears that that is where the judge is locating this use and where the defendants admit that the use is, that there isn't a finding in relation to that. But of course, that would be dependent on me succeeding under 10.1 on the marks as well, if I'm going to be running those arguments. But we say that should have happened, yes. Now, you've seen the EasyGroup marks, and you'll recall that they are marks for plain word in all caps, which means the word protected as such. Then there's a configuration with the camel capitalization, and then there's a colour version and a black and white version. And that's the 528A, and then there's the 509, which is the EU mark, which is word only, and then 376, which is the decorative, the colour logo. Now, of that, we say there was infringement of double identity only in relation to the word-only versions, and we say 10-2 infringement under the others. Now, where did the judge go wrong, apart from this issue of 10-1? We say that the judge also erred when it came to the comparisons of which sign, which mark, and over time, the significance of those to the assessment of an absence of confusion. Obviously, critical to the judge's reasoning was there is no confusion. There's no instance or evidence of confusion, and that's significant because one would expect some. That seems to be the analysis. We say that, first of all, there was some evidence of confusion. Secondly, this was not a case where any safe inferences could be drawn from the evidence, the lack of evidence of confusion, not least because there was no real-world proxy for the actual signs that were being compared. So what I mean by that is the judge compared EasyOffice word solus against EasyOffice's word solus and regarded an absence of confusion in the marketplace to be probative on that question. But it couldn't be because they weren't used in that form. They were word-only marks. And the judge had herself found that where there was colour involved or where there was a connection to the family of brands, that might lead away from confusion in some circumstances. Furthermore, when it came to Mr. Abraham's nuclei use, there was a host of different fluctuating signs from the outset up to the present day. And it was very difficult to say that there was any particular period that would be the period in question that matched the absence of evidence of use, evidence of confusion in question. Now, in the judgment, it is said that we ought to have found evidence of confusion for the 5-year period. Let me just find the exact part of the judge. There is no evidence of actual confusion. Yes, it's 320. It is striking that there's no evidence of actual confusion as between EasyOffice's marks and signs, despite side-by-side use of those from 2007, signs above, until around 2012. Now, that's a relatively short period, quite a long time ago, and most importantly, there was no disclosure from the defendants at all for that period. It stopped at 2013. So there was zero disclosure from Nuclei in relation to that. And he put in some self-serving documents about his publicity activities, which rather raised the question why he had those and not adverse documents, but never mind. The point is that there was no disclosure of adverse documents such as confusion from the defendants. Now, the judge dealt with that by saying, well, yeah, but EasyGroup had material going back earlier. Well, actually, I mean, that's surprising because the sort of material that EasyGroup would have on this hypothesis that we're saying their sign confuses our mark, it's going to be wrong way around confusion at best. It's probably going to be wanderers or busybodies saying they look a bit like you. The people who are going to have real confusion are going to be the defendants, inevitably, in a case like this. Not always, but by and large, and that was dismissed. The point that perhaps is most important is that if you look at 316, the judge is comparing EasyOffice's word against EasyOffice word and black and white figurative mark, which she says is similar to some of the logos used from 2011 to 2019, those are different from the period in question where she says it's very telling that there's an absence of confusion. Now, we can perhaps have a look at the pictures of the nuclei side, but it's not at all the same side. And one can see, broadly speaking, actually no, there's an easier way to look at this, I apologise. In the judgment, there's a pictorial summary of the EasyOffice's side. So if you pick it up at, you've got tab 20, and you've got paragraph 25. We start out with this sort of the Ford logo, as it was sometimes called. Then there was the orange and white, which we complained. Sorry, burnt orange, you want to say? It was very important that it be called burnt orange at trial. And then 27, following correspondence with EasyGroup, which is discussed further below, Mr. Abraham's commissioned a revised logo, and that's so 2001. But then the key point is that 28, we've got those logos. Now, the judge is concerned with the period from 2007 to 2012. So largely speaking, that first logo, but she doesn't analyse that logo, never compares that logo, whether it's similar or not. And indeed, the ones that the judge finds to be most similar are word only and anything light on dark, so the ones that come later. EasyOffice's 2011, EasyOffice's 2015. So it just doesn't work as a proxy for the comparison that the judge is carrying out. There's only 1 year overlap in the sense that we were, on the judge's findings, no longer using from December 2012 at all. And yet that year we were regarded as having used enough to be generating large amounts of trade sufficient to cause confusion, or at least for people to confuse the defendant with us. There's an inconsistency in the findings there, we say. And looking at the defendant's trade, they themselves were, their total turnover, I think at its highest was about 1.4 million, and averages around, Bob's around the £1,900,000 per annum. This is total revenue. The judge, we say, was extremely generous to find that was a large business in the office rental space, but I don't particularly wish to challenge that. I don't think we need to challenge it, because it doesn't matter whether you call it large or small, it isn't sufficient to come to enough people's attention, we say, to be generative of confusion in the light of our, by then very declining use, and the various signs that were being considered, or that this was said to be the real world was said to be testing. So we don't accept that the judge was correct in relation to the significance of evidence of confusion. It is always a slightly controversial thing to rely on instances of confusion, because that's the views of those particular people. Are there very many? What were the circumstances? And so on. But it's even more controversial to regard there as being not enough. There was, of course, one piece of confusion that we do rely on, where there was the director of the first defendant in 2015. There's an email. This was, of course, within the period that they were disclosing information. The director, I've asked you please to take SB1 and SB1 tab 26265. And this is Andy DeWitt-Steen, who's one of the partners of the directors of Mr. Abrahams, the director of Nuclei, writing in 2015 to Tim Feldman. There was evidence as to who these people were. new homepage is not converting as well as old one, as mentioned. I think this is more to do with people thinking the old website was Stelios more than this website is. Brand was 4.2% conversion, now 3.1%. Let's get the homepage ranked better first and then worry about CRO, conversion rate optimization. In other words, let's worry about the conversion rates. Later, let's get the page ranked better, page rank referring to where it appears on the Google page. So this was dismissed by the learned judge as being simply speculation on the part of this person. And at one level, that is true. But it is data-backed opinion by the director of the defendants about customer or transactional behaviour. Conversion is when the consumer actually takes a step, clicks on something, buys something, and it acknowledges at least a risk of confusion in both the old version and the current version. So the old one is worse than this one in terms of non-client's rights. Now, it was suggested, I think by my learned friend, or maybe the evidence, that somehow that reference to Stelios was not of confusion in the trademark sense, it was in the sense of no frills or the brand values. That doesn't make much sense, given that the conversion increased as a result of the no frills connection. We say that's clearly an acknowledgement, so far as it goes, that there was a risk of confusion, and it's in a sense better than a consumer, because the consumer just can really speak about their own confusion, whereas Mr. de Wittstein is speaking about a number of people. He's talking about traffic. Anyway, this was not given much significance. And we say, at the very least, this made it very unsafe to say, well, in the absence of the defendant's disclosure, we can be sure there was no confusion. No. That document, if nothing else, suggests that you can't draw any safe inferences. By the way, I'm not making adverse inference as a result of lack of disclosure. What I'm doing is saying that they shouldn't get credit, which is what they got from the judge, by there being a positive finding that the absence of evidence of confusion is existence to the defendants. There's one point we make on that about burden, my lord, and I don't know if I'm addressing Lord Justice Arnold in particular, in the light of the Musmatch case, that we say if a defendant is going to come to court and allege or rely on an absence of evidence of confusion, although the general burden in the case is on the claimant, on that particular issue, the burden is on the defendant, because that's drawing an inference from the absence of something, and it is a particular, well, the outcome of that issue, the determination of that issue, is effectively a defence. And so we say, to the extent, it's not essential to the appeal, but we would suggest that it is actually for the defendant to prove that a safe inference can be drawn from the absence of evidence of confusion, and that there is actually an absence. Now, Mr. Wittstein was not called as a witness. One would expect him to be called, explain what they say about it being mere speculation, and we'd expect the disclosure or for them to strain every nerve to make the point good, and they haven't. But we don't need to go that far. We say simply the case on absence of confusion simply wasn't made out.
Who are Axiom? Because obviously Mr. Elmingham wasn't called either.
Yeah,
Who are Axiom?
There was some discussion of this at trial, but I asked Mr. Abrahams about it, but of course Mr. Abrahams said he was outraged and astonished to see that there was confusion. Well, we may be able to assist you with that later. Just a moment, I'm seeing if I'm... Yes, the context of the use. Yes, there was. Okay, there's a point we make about the comparison as well. It's a sort of separate point, and that is when it comes to the comparison of marks. The judge only compared the visual and conceptual for some reason, not considering the phonetic. I'm not sure why that was, but it's axiomatic. You've got to consider the visual, oral, and conceptual. We say that is something that should have happened. Overall, when you look at the judgment, even on the judge's analysis, similarity of services, similarity of signs, distinctiveness, and the comparison itself, they all pointed in one direction, and it almost seemed as if the judge herself would have gone in that direction, but considered that the absence of evidence of confusion was something to lead away from that. And we say that's not right. That's actually got it backwards. A judge should, in general, decide a case as a jury question. It's a question of fact for the judge. And usually evidence in trademark cases is over-elaborated anyway, and it can be a matter of deciding a simple risk of confusion. Looking at these two signs, I mean, it was EasyOffice and EasyOffices for two websites that are doing the same thing. It was just remarkable that the judge didn't find a likelihood of confusion. Me and a friend got an absolute windfall finding in this case, and neither of us were prepared to really address this until the judge particularly asked for explanations, because it was a sort of thing that almost went without saying. The case was going to turn on other issues. Honest concurrent use would be one of them, and I'll deal with that relatively briefly, if I may. We deal with that in our skeleton. We deal with that in two parts of our two skeletons, and I think it's probably best if I just show you those, because one of them was pre-Musmatch and one of them was post. So in the first skeleton, we focused on the honest practices and the lack of honest practices. This was not a case in which it could be said that there was honest concurrent use, because it was a case where the parties had been, putting it bluntly, at each other's throats for many, many years. There were allegations of sham use in this case. There was allegations of applications for marks on bad faith. There was a defamation trial. Each party had written threatening letters to the other. I know my learned friends will be discussing that tomorrow when it comes to the res judicata case, but this was not a happy concurrent use, and it was not one where either party accepted that the other could trade as they wished over time. So we focused pretty much on the honest practices aspect of it. If you look at the core bundle, tab 12, page 79, paragraph 59, it's fanciful to talk of the defendants complying with their duty to act fairly in relation to the legitimate interests of the proprietor. They launched the first trademark proceedings against claimant, and there have been numerous invalidation proceedings. Indeed, the res judicata, the basis of that, and the successive attacks on that, the purchase of third-party rights and the deployment of those in the service of the wider battle. We say, as to whether the defendant was aware or ought to have been aware of the existence of substantial or confusion or deception, well, they both were saying the other was causing confusion. There's a letter from McDermott, Will and Emery, written on behalf of Nuclei, paid for by Regis, alleging exactly that. And the judge also made no consideration of whether acts of the defendant have exacerbated the level of confusion. In that respect, you'll recall a moment ago I showed you the passage of the judgment where the judge says that the white on dark versions of the EasyOffice's site were closer or close to even the logo form, logo form monochrome, logo form of the 528A mark. Well, that came later. So that honest concurrent use is to be assessed over time, and we have a continuum of use, and it might be said that the orange was a bit close and then it was moved away with the blue, and then it came back with the white on dark and so on, but this is the point. And by that point, of course, the EasyOffice business was low level in terms of the Croydon premises, or then closed. So we just say this is not a case, moving to the more basic requirements of honest concurrent use, which we fully accept from the Musmatch case. This is not a case in which there was sufficient trade for long enough that anyone could say that there was no damage to the essential function of the marks as a result of the trade of the other. That there was a sort of common perception in the marketplace that there was such a situation, and the defendant didn't even try to prove it. This was just asserted. The defendants didn't. Indeed, their whole case was that the EasyOffice mark hadn't been used for a very long time. And so it's very difficult to see how they could then at the same time be alleging no damage to the EasyOffice marks as registered through an honest concurrent use. We say the case didn't even get into honest practices. In fact, most cases won't need to, because they will fail on the basic Budweiser criteria. That you've got, it's an exceptional case that parties can establish as part of a defence that there is no likelihood of confusion, because people have learned through the use being long enough and strong enough that there is no, there are effectively two EasyOffices, one belonging to us, one belonging to Mr. Abrahams, and that is, it's just very hard to prove those facts. And it's important, we say, and welcome that the guidance comes in the Musmatch case, because honest concurrent use was in danger and was deployed in this case as being a sort of get out of jail free card. I've used for a while and therefore I don't infringe. And that was the way it was being argued, and indeed sometimes determined in cases. And that it is not the position. It is not provided for in the directive or act, and it is a part of the defence of lack of confusion that is made out in very, very particular and exceptional circumstances, of which this case is nowhere near. For good measure, the judge didn't say anything at all about the current sign, the swirly one, that my Lord Justice Nugee was asking about, that page. So the sign that was used then was not compared with any of the marks. And then so far as the, wasn't compared to 528A or any of the marks there. There's an important point there, which is that all of the earlier marks have to be compared with all of the logos, because we were complaining about, and if you look at the particulars of claim, we amended as we went along and they kept changing their logo. We updated it so that all of the logos are at issue, plus word only is in issue. And so we were relying on all of those signs, and they weren't all considered. Just one moment. I think I might have come to a natural end. Just a moment. Oh, great. Yes. Axiom. Tim Felmingham was a website designer that we shared office space with, I believe, I might have been, how long have you known Tim, or Andy has known Tim? Tim at Axiom, 15 years, something like that. So that's all we have. Oh, sorry. I think he actually, it was a bit more, I apologise. 15 years, something like that. I think at the time he may have been doing some consultancy with us. So I do not know if he actually designed the site. I think he was just helping us with what we would call CRO, conversion rate optimization, which is helping people fill in forms, ring a number, things like that. Understood. There's a page reference for that, is there? SB1 37314. Yes, I mean, of course, Lord Justice Arnold was familiar with the Musmatch case, he wrote it, but it may be that that would be a good case to look at when it comes to the decision on the case. I mean, I might just very briefly show it to you, and then I'll stop. That's in the UK authorities. It's very recent, last week. It's tab 55. Bundle 4. So tab bundle 5. I'm reminded, of course, both sides are relying on this, so it's well that I take you to it. The facts are not particularly significant, but the parts that we would wish to rely on are where the the Court of Appeal is sort of analysing the basis of honest concurrent use, which is of course a specific defence under the old law provided for in terms. If one picks it up at page 1522, paragraph 62, I turn to the most important issue raised by this appeal. The defendants contend they have a defence to the claimant's claims of trademark infringement and passing off by virtue of honest concurrent use. The starting point is that the judge adopted what Lord Justice Arnold had said in the W3 case, which was sort of a fairly, fairly sort of basic, well, because the point didn't need to be absolutely decided, there was a sort of provisional view expressed. And then there's a discussion of trademarks law prior to the 94 Act.
Yeah, well, and I don't think it's profitable for present purposes to go through this ad nauseam. I think we need to focus on the points that matter.
I understand. I mean, I understand, of course, Lord Justice Nugee as well is involved. So I don't propose to do that in that case. The key points from our position are the burden is on the defendant. It's a very exceptional case that will establish this. The trade, the level of concurrent trade, in this case, didn't come close to establishing the basic propositions, and of course the honest aspect or honest element was wholly missing in relation to commercial litigants with some very robust allegations flying around for quite some time, and the public fundamentally had not learned to tell these two businesses apart, and there's no basis for inferring that they would have, much less on a sort of contingent basis the judge found it. So I think I was proposing, so I'm going to speak further on those two grounds in my submissions.
May it please you, my lords. I intend to structure my submissions to you firstly by giving a very general overview in relation to the infringement case, very general overview in relation to the revocation case, the non-use case, and then deal with infringement and then non-use revocation. I will then, after that, go to consent, need to be, and that probably needs some time tomorrow morning. General comment in relation to infringements, if I may, my lord. By this appeal, this court will have appreciated that EasyGroup is seeking to restrain Nuclei from trading under the EasyOffice's name and signs, a name and a series of signs which Nuclei has continuously used in relation to its brokerage business since 2000. Prior to any use by EasyGroup of any EasyOffice sign in any form, and prior to EasyGroup even filing any registered trademarks for EasyOffice. That only happened in 2002. They're seeking to restrain that use in circumstances where EasyGroup has known of Nuclei and its use of the EasyOffice's name since at least 2001, has sought and accepted undertakings from Nuclei that it would not use the EasyOffice mark in a particular get-up, but has made no complaint or threat in relation to infringement at all. It had made no attempt to restrain Nuclei's use of the EasyOffice's sign and name for 18 years after it accepted those undertakings, and until EasyGroup served its claim form in proceedings without warning on the 15th of May 2019, had made no attempt to restrain by registered trademark infringement the use of EasyOffices by Nuclei. During that period, EasyGroup and Nuclei have been involved in numerous trademark oppositions and validity and revocation actions in respect of each other's marks and filings both in the UK and throughout Europe. I don't need to go to it, but my learned friends put in the bundles, SB3, tab 25, page 131, a list of all the revocations and invalidity actions which were taking place since 2007. In the marketplace, however, the businesses of EasyOffice and EasyOffices had coexisted without incident since 2007, when EasyGroup launched its own business under the sign EasyOffice at physical premises, and by using what appears to be an Instant Office's white label usage too. That business petered out in about 2012, and the judge held that genuine use ceased in 2013, December 2012. But not a single instance of actual confusion throughout this time was identified. So by this claim and appeal, what EasyGroup is seeking now is, as a matter of registered trademark law, to restrain Nuclei from continuing to use the very sign, EasyOffice name, which is used in relation to its brokerage business in the manner which has now been known for over 23 years, and to claim damages back to 2013, because that's the effect of the 6-year limitation period. We say, just in those brief circumstances which I've outlined to you, it's not surprising that the judge found non-infringement, and observed that if it had been necessary as a defence was available, that the common law acquiescence would have been likely to have arisen. She had considerable sympathy with Nuclei's position. It's judgment at 339. We say the judge was right to do so. She applied the correct law as to trademark infringement to the facts which she was entitled to find, and on a proper analysis, EasyGroup has failed to identify any error of principle in relation to her reasoning or application of law in relation to the question of infringement. Rather, what my learned friend is trying to do this afternoon is just simply to overturn the decisions this court made by seeking improperly to re-argue a factual assessment on the appeal, or to make points which are wrong in principle or bad in law. As to the general position in relation to non-use, it's common ground that by the time this claim form had been issued, EasyGroup had ceased to use the EasyOffice mark in relation to any business at all. On their factual witness statement evidence at trial, that use was said to finish by 2017. it was also common ground that the EasyOffice business, which had previously been run by the company known as EasyOffice Limited, was in relation to a company which had gone into liquidation in July 2012, as the judge found in Judgment 41, and that business essentially petered out. Therefore, we say it was highly surprising that a party as sophisticated as EasyGroup, which at all material times has been advised by highly experienced specialist city solicitors and has access to the top IPQCs in this country, and which has been a party to numerous bits of litigation for this court, for the High Court, both in this country and in Europe, and which knows, pursuant to Section 100 of the Trademarks Act, it has the burden of proving use in relation to its EasyOffice marks. Highly surprising. It's also led evidence in relation to such disputes in many cases in the UK and Europe before, would lead a single factual witness statement, which purported in a mere 5 paragraphs to give the entirety of the factual evidence of actual use which EasyGroup claimed to have made of the EasyOffice mark during the relevant period, i.e. between 15th of May 2014, 15th of May 2019. Those are the 5 paragraphs in Sir Stelios's witness statement, which I need to show you briefly so you actually understand this was the high watermark before the start of the trial of the evidence of factual use which EasyGroup relied on. It's in the supplemental bundle, tab 19, live witness evidence, sorry. Tab 19, page 155.
Which supplemental bundle?
Sorry. Supplemental bundle 1. I apologise, my lord. I should pick it up at 154. This is the extract of Stelios's witness statement. And paragraphs 39 through to 43 were the totality of the evidence, factual live witness evidence, which EasyGroup sought to rely on before this court, sorry, before my lady, Mrs. Justice Bacon, at the trial. And the relevant paragraphs 39 through to 43, and I would just, so I'll ask my lord to recast your eyes over that, but what he is talking about from 39 through to the penultimate sentence of 43 is the nature of the serviced office use at Croydon. And the only substantive evidence in relation to the white label use, the so-called instant office use, is the last sentence on 43. Now, in our respectful submission, that evidence was always going to be incredibly thin when you're seeking to prove genuine use. It, however, became even more extraordinary when, as now accepted by my learned friend, that witness was rightly found by the judge to have been deeply unimpressive, argumentative, implausible, gave contradictory answers, had a poor recollection, and had no personal knowledge of the material facts at all. That's the judgment 13. The paragraphs could only at best be given any material weight if they were corroborated by other evidence in the case. The judge also formed the view that the statement had been drafted by lawyers, and it became apparent during the cross-examination that the witness had no helpful evidence to give about these matters of use during the relevant period. There was no other witness called by EasyGroup in relation to use during the relevant period, despite the fact that there were other people who were available and who apparently still were actually employed by EasyGroup, who apparently had direct personal knowledge of the relevant, or what would have been the relevant events, and could have given evidence of actual use during the relevant period. So this was the extraordinary case of genuine use put by EasyGroup at this trial. And so by the time of closing, my learned friend was forced, gallantly, to trawl through his entire disclosure, which consisted of more than 18 lever arch files, files F1 through to F18, totaling 7,500 pages of documents, to try to identify any possible document which would potentially enable them to put together some piecemeal narrative to argue that there had been genuine use during the relevant period. In their opening submissions, EasyGroup had annexed a lengthy annex, that's SB1 tab 5, containing a long list of references to documents, very few of which were mentioned orally by EasyGroup, and only a portion of which actually related to the relevant period. At all times, EasyGroup grouped these references under two relevant headings, present purposes: use at a single Croydon office location and use on a white label website using a third-party party called Instant Offices to provide a directory of offices around the world. The judge addressed the case put by EasyGroup at trial, together with all the relevant documents which EasyGroup relied on at that time, many of which you will have seen in the judgment she held to be contradictory. For example, judgment page paragraphs 275 compared with 277, the payment record from Instant Offices relied on two different payment records, and they were contradictory, or were incomplete. For example, the website pages did not show the transaction process of Instant Offices, or were anomalous and unreliable, judgment 280, or were not kept up to date. And I need to show you that. That's an admission made by my learned friend during his closing submissions. So could you take SB1 again, Supplemental Bundle 1, tab 37. And this goes specifically to the website pages. Go to tab 37 and look at, please, page 322. And I can pick it up at manuscript page 697 and at the Mr. Manager's making submissions. I'll tell you, line 7, I'll tell you what, I think probably the best thing is, if I'm going to do it that way, I'll be quick if I just ask those to collect those three either authorities, the relevant paragraphs and tab numbers for those, and I will look at the evidence again. I'll wait for that. Then we have the AdWords campaign. We have the fact that Croydon was featuring on the website. The website is linked between both facets of the business, the Instant Offices and Croydon. Until 2006, mid-2016, until 2016, mid-2016, the office remained open, and my learned friend takes the point that online reservation system was abandoned, the website was inaccurate and not kept up to date. That, in my submission, is typical of the criticism. Yes, and it makes no difference. I mean, yes, this is not a flourishing business. This business was petering out, spluttering out, and things got out of date. My learned friend does not deny that the site was there with EasyOffice branding on it. That's trademark use. There's authoritative proposition. So you have to be aware that what you see on the website pages are not reflective necessarily of what is actually going on as a matter of fact in the real world. And the classic example of that was that the website pages contained things like references to offices which my learned friends accepted had closed long before that website page still presented that office. And of course, as the judge found, there was no narrative explanation as to the contents of almost all of the disclosure documents or what they represented. And that left the judge, as she rightly pointed out, with gaping holes which required speculation for her to fill. We say, therefore, together with the relevant and correct concessions which were made by EasyGroup before her, the judge came, we say, not surprisingly, on the materials that were actually before her and the materials which had not been put before her, to the conclusion that EasyGroup had failed to establish genuine use of the EasyOffice mark during the relevant period, even though there was evidence, some evidence, of some commercial trade under the EasyOffice sign during the relevant period. The evidence assessment by the judge in the special circumstance of this case was, we say, impeccable, and one which was uniquely for that trial judge to make. She applied the correct law in relation to the evidence and made the correct multifactorial assessment of the evidence and whether that supported a case of genuine use. As a result, we say, having heard my learned friend this morning, he's failed to identify any error of principle that the judge took in coming to that conclusion. Rather, what EasyGroup are trying to do now are, by island hopping through the documents, to select a different combination and selection of documents to show the court, merely to ask this court to come to a different conclusion without having heard the entirety of the evidence or even the material completeness of the documents, and in the absence of an error of principle. We say that's not a legitimate approach on this appeal. As to that, my lords, you're a highly experienced tribunal. I don't need to remind you, but just for your notes, we have given you in our second appeal skeleton, paragraphs 3 to 4, Lord Justice Lewison's well-known statement in Phage, and we've given you in relation to paragraphs 23 and 24 the problems this court has of selecting images as well. So, I mangled that. We've given you the general principles set out at the second skeleton, paragraphs 3 and 4, and at 23 and 24, we've also given you principles about reviewing multifactorial assessments. Now, with that overview, I'd like to dive into the infringement appeal first, if I may. Now, to help orientate you, because I find it difficult sometimes understanding what my learned friend was saying in relation to some of the marks, I would ask if you would take out the judgment and go to page 7 of the judgment, where you see helpfully set out paragraphs at the end of paragraph 21 and paragraph 22 of the judgment, where she sets out in tabular form images of the trademarks in question and the services in respect to which they are registered. So we can just simply orientate ourselves as to where we go. There were 4 marks at trial. 502 fell away straight away because EasyGroup accepted there was no use in relation to that ever made. UK 528 and EU 509 can in one sense be considered together, because they're the ones which are only registered in relation to the what's been called the physical premises use, the rental of offices or half-temporary office space. They don't have any use in relation to information or advisory or consultancy services. That's what EasyGroup had registered as of 2002. By 2013, they'd expanded the scope of their registrations and filed a new one, 376. 376 has the additional services which include information advisory and consulting services. They're the ones, just jumping ahead, they're the services which the judge found were identical to what Nuclei had used and would have been identical to what Instant Office's use would have been if there'd been sufficient evidence to prove that use. But you've held that they weren't identical. Sorry, the 528 and the 509 marks services were not identical to Nuclei use. Clearly not, because Nuclei had never had any offices to rent. Now, as to, just in terms of overview, again, as to identity, 10.1 identity, you'll see from the images at the top of the page that 376 could never be identical because it's a particular get-up logo. 528, the last two were particular get-ups as well. So the only ones which were candidates for double identity were 528 and 509. So the starting position was, at best we say, an attempt to go for identity in relation to the sign and mark, but different services from the outset. However, we'll come back to that. The judge held that the word EasyOffices was not identical to any of the marks, even the word marks. And we say she was right to do that, and I'll show you why. And as to construction, as I've already foreshadowed, she said that there was no identity between the service, which you can see in classes 36 and 43, i.e. hiring or renting of offices or temporary office space on the one hand, and the service of providing information, advisory and consultancy services relating to the service of hiring or renting of offices and temporary office space on the other hand. Namely, the distinction that the EasyGroup themselves had taken when registering in relation to the 376 mark. We say that's a perfectly reasonable approach for her to take. But it is why it's important to always have in mind that you did find identity in relation to services, but it was limited to the 376 mark. It was common ground and that Nuclei never had any physical premises to rent or hire, and it was also common ground that instant offices, insofar as it's providing services, was providing services directly competitive with Nuclei. What we also say, and I'll show you in a moment, is that the judge found as a matter of fact that the brokerage service, which was provided by Nuclei, was identical to the 376 service of providing information, advisory and consultancy services relating to the service of hiring, renting of offices and temporary office space. That she found in 299 and 301, and I'll show you again at 304 and 215. Again, by doing so, we submit the judge made no error when construing the various specifications of services which the EasyGroup had obtained, and no errors in making findings about fact as to what services Nuclei was in fact providing under the EasyOffices sign. As to the likelihood of confusion, when stripped of my learned friend's advocacy, what EasyGroup is really submitting is not that the judge erred as a matter of principle when making the multifactorial assessment, but rather she was wrong about a number of primary facts, not open to them on this appeal, and should have given different weight to the facts which she did probably have regard to and relied on, again, which is not an error of principle, nor is it evidence that she was wrong. And again, as I've indicated, what they really complain about is that they want to do now is ask this court to make a new determination, having gone through the documents again. Now, with that further overview of infringement, double identity, if I may. Sign and mark, similarity or identicality. For your orientation, we've addressed this in our second skeleton argument of paragraphs 25 to 29, but I'm not going to repeat what's there, but I'm going to try to highlight some key points in relation to this, if I may. If you've got the judgment open, as I said before, this can only really apply to the 528A and the 509 marks. And it's fair to observe that at trial, EasyGroup advanced its case on double identity very half-heartedly. It only focused on the word marks in relation to this aspect and suggested it did not matter particularly because the case could always be decided under section 10.2. We say that was a very fair thing for them to do. As to the word marks, the judge did record that they were different, contrary to my learned from submission this afternoon, and there's a reason for that difference, but they were almost identical. Let me show you in the judgment. Could you turn to paragraphs 228, which my learned friend didn't take you to. And the reason that, just so when you're getting, the reason the judgment is sort of cast in this way is that she dealt with the invalidity counterclaim first, and so was dealing with the mark sign comparison in the context of passing off, and then went on and dealt with the similar sign comparison which she had to do with the infringement judgment. So what she said in 228 is important because she's considered the logo marks before and dismissed them as being too dissimilar to give rise to the likelihood of deception. But in relation to the word marks, the meaning of word marks, she says EasyGroup itself says that those marks are almost identical to the EasyOffice sign used by Nuclei. The only difference being the S on the end of EasyOffices. There was a difference, and it was recognised as a
So
difference.
where do you say the judge addressed her mind to the LTJ test?
I don't say she expressly set it out, my lord, but I say she has taken it on board and has come to the conclusion that there is a difference, and she's entitled to come to the conclusion there's a difference, because the way in which it was actually put before her was they were only almost identical, and they weren't put on the basis that they were identical. And as a matter of law, when I show you the law, unless they were identical, then the judge was likely to find...
Sorry, let me be clear.
Yes, of course.
It's one thing to submit that it was not EasyGroup's case that there was any identity in the first place. That's a perfectly understandable submission. But if you accept that they did advance a case of double identity, then what one's looking for is an assessment as to whether mark and sign are identical, applying the correct legal test. And I think you've just accepted that nowhere in the judgment do we find any articulation of what the legal test is, let alone application of it to the facts.
I agree to the latter, and I say it's unfair to the judge to criticise her in that way, to expect that, when in theory, in my learned friend's opening written submissions, he cited LTG and cited in theory a case which could be run on section 10.1 double identity. But in practice, his oral submissions to her and the evidence in front of her was that both he was saying they were only almost identical, and EasyGroup themselves had treated these marks as being almost identical and not identical in the evidence. So it was fair for her, by the time she came to the judgment, given the huge number of issues we had to address, to treat that as a non-point. But by the time we'd actually gone through the trial, no one was actually seriously contending that these marks were identical. And that in my submission is what she's done, and what she is seeking to encapsulate when she says at 228 that EasyGroup itself says these marks are almost identical, but not accepted.
So just so as I can be clear about the point,
Yes,
you accept that LTJ was cited in opening,
in writing only,
and
not orally, and by the time she got to oral opening, it wasn't. And at oral opening, they said it was nearly identical. I'm going to show you the passage more, because it's not fair to the judge.
Is it your submission that the case of double identity was abandoned?
In practice, my lord, yes.
Do we have,
I don't think I've got anything to say strictly they've abandoned it. They didn't formally make any admissions to abandonment, but in practice, before the judge, by the end of the trial, it had been abandoned. And it's not well for them by them actually opening orally on the basis that they were only nearly identical, not identical.
do we have written closing submissions?
You do, and you have, I think, probably only parts of them, but you have all the infringement. Yes, you do. You should have all, and you should also have all the closing oral submissions on my own friend on infringement as well. So what I was going to show you was in relation to the way in which the case was put even on day one of the trial, and that is again back into the supplemental bundle 1. And it starts at tab 37. Page 290. Sorry, I think that's page 290 of the manuscript. I do apologise, make sure I've got that right. I do apologise, it's entirely my reference. It's page 28 of the manuscript, which is page 290 of the bundle, and you can pick it up probably put it full context. If you pick it up at bottom of page 15, at line 19, this is again my learned friend, then I propose to look at consent, which is really the next event after each business plants their flag, so to speak.
Sorry, where are you, Mr.
I'm sorry, I'm at bottom of page 15 of the manuscript, bottom of page 289, just to give you the context of when we get to the submission by my learned friend at 290. So it's the manuscript, page 15, bundle page 289, line 19. Put into context, it says, then I propose to look. Oh, no, sorry, I apologise. I can't do that. Sorry, I apologise. That's entirely my fault. The pages don't follow. Let me just pick it up then at page 290 of the bundle, manuscript page 28, line 4. So really, the objection about descriptiveness only goes so far if that issue was before the court in some way, and so far as we can tell, it's not. The reason for that, of course, is that defendants want to claim distinctiveness in an almost identical term, a pluralised version. That is, the last thing they want to say is it lacks distinctiveness. And that's as far as we get in terms of submission in relation to identity of the...
So that's an abandonment of the case on double identity, is it?
And so far as he made no positive case of identity in any other way, yes. And that's coupled with the material
and that's
facts.
in the context of a discussion about distinctiveness,
It
not,
is not.
not his infringement case.
No, I accept that. And he doesn't address his infringement at all. And I also accept that it's not canvassed at length in the judgment. But I also say, in context of what was actually put before the court, was that EasyGroup was saying, amongst other things in their evidence, that the mark was almost identical, but was not identical. That's Stelios's evidence, which he gave, which is in SB1, tab 14, page 135, paragraph 57. In fact, before the court, that witness statement had 3 further references to treating the distinction between EasyOffices and EasyOffice as being almost identical, but not identical. So, I accept this is an unconventional judgment insofar as my Lord is expecting to see in-depth analysis of, is EasyOffice identical to EasyOffices, and is that difference so much that it's likely to be so insignificant that it may go unnoticed by the average consumer. You don't have that, but that's because the practical reality of this trial was that the point was not pushed. And what I'm saying is the judge was entitled, without giving 4 reasons, to accept that that was right, because on the law, she was entitled to come to that conclusion without giving detailed reasons in any event, because there was a material difference. There's an addition of an S that changed the word from being EasyOffice to EasyOffices. That's a plural. And I'm going to show you the passages in Reed that my learned friend didn't show you about showing differences of that sort are exactly the sort of thing which take us out of identity. And I'm also going to show you the EU guidelines, where again, a 1-letter difference is classically understood as being taken out of identity, both of which were cited to the judge by us at first instance. So in relation to Reed, my lords, could I ask you to go back then to the authorities bundle at tab 21. So that's authorities 2, tab 21. My learned friend took you to, in the authorities bundle, page 520, up to paragraph 25, and went no further. And we say that's rather unfortunate, because what Lord Justice Jacob then did was to try to give some clarity to the opaqueness which he thought had been previously discussed.
To be fair, Mr. Mallett did mention what had been said at 27.
He did. But yes, he didn't then mention, didn't show 28, which was the Advocate General's opinion, makes it clear that, save for the plaintiff, no party, the defendants, the Commission, the French and the UK governments, contended that anything other than strict interpretation Moreover, although there's nothing expressed in the tenth recital about a danger of confusion being presumed in the case of identity, both the Travaux are explicit on this point. And the TRIPS agreement.
I don't understand that at all.
No,
Because Article 16.1 expressly tells us that confusion shall be presumed where there's double identity.
my lord's going to give a couple of judgments on that if I remember correctly. Anyway, the important point.
More than a couple.
The important point is that paragraph 29, also, the Advocate General's opinion is also helpful in indicating the sort of differences which would be so minute as to leave the mark and sign identical, and those which would not. He said at paragraph 50, I suggest that reproduction of the plaintiff's mark in the same distinctive script, but without the dot under the initial A, might well have been perceived by the average consumer as identical to the original, the change being minute and wholly insignificant, whereas the use of a notably different script and or the addition of another name might be seen as only similar, such changes at least taken together being substantial. And then in 30, it points out that policy there makes sense given the system as a whole. 31, nor do I think it makes any sense the identification that trademark use includes spoken use. That makes it explicitly clear. Providing the reference to use also includes use otherwise a means of graphical representation, though there's no corresponding provision in the directive, it seems fully clear that implicit, purely oral use may count for infringement, blah, blah, blah. Therefore, it's implicit that from this that the concept of use is very wide and must surely cover all use. It follows, I think, that in the case of any accused use which has some visual significance, one must take into account in considering the question of identity. The visual impact may be slight, but it will count even if the marks are identical to the ear. You can only have identity if there's both oral and visual identity. Well, here we have neither identity as visual, nor do we have identity as to oral use. And this is exactly the sort of difference that day in, day out, the EUIPO rejects as being an example of identical mark. We put that in our skeleton, but I can show you in the EUIPO guidelines. They are in the authorities bundle 6 at tab 76. And if I may ask you to turn to page 1780. Section 2.3, identity of word marks. Word marks are marks consisting of letters, numbers, and other standard typographical characters, reproduced in standard typeface. That means they do not claim any particular figurative element or appearance. Where both marks are registered as word marks, the typeface actually used by the office concerned in the official publication is immaterial. Differences in the use of lower uppercase letters are in general immaterial. Word marks are identical if they coincide exactly in the string of letters, numbers, or other typographical characters. And then if you drop down to immediately above the last table on that same page, a difference of just one letter is sufficient for the finding of non-identity. Novoloi, novoloi. Herbo farmer, herbo farm. Whether or not space or punctuation mark or accent or the use of combination of upper and lower that departs from the usual way of writing introduce a difference is so insignificant it may go unnoticed by the consumer in accordance with Arthur and Felice. It is assessed on a case-by-case basis, taking into consideration relevant language and so forth. So we say that implicit though it is, the judge had applied the right law to the factual situation here where the mark and sign were not identical but were nearly identical. And she was right to take as a concession or alternatively implicitly understood the decision, that she was making a decision that these weren't identical marks. So even if, it's everything else, even if she made a complete error here by not addressing it, there's no material error, because if she had addressed it on the LTJ basis, she'd come to exactly the same conclusion.
If she did make some error and not applying the right test, then any reason why we shouldn't apply the right test ourselves?
No, and I suggest if you did apply the right test, you come to the same conclusion.
We only have to concern ourselves with EasyOffice, the word mark. We don't have to concern ourselves with the the one that has the capital O, the camel?
You do. You have to, strictly speaking, you have to concern yourself with all of the marks. But if we go back to the judgment at...
it's the second mark in the series.
It's the second one says, my learned friend sought to say that, as I understand it, as far as one is his identicality case, it was word marks and even the word mark which had the camel hump in as well.
But why does it make any difference?
It doesn't.
If you've got infringement of one, that's enough.
You have, and the other way round, we say, if it's not identical in relation to the word mark, it's not going to be identical to one which is even more dissimilar because of the particular typeface presented by EasyGroup in their second of their string on 528. So remember, just looking, my lord, at whether the sign and mark are identical.
Yes, but why do we even need to ask the question?
Well, arguably, that's one of the points I asked my own friend before we started this bill. Do we really care about this in any event? Because everyone accepts these marks are similar, and we're already into the 10-2 territory. It's an important plank of his case, though, that he can say the judge went wrong, because this should have been a 10-1 case right at the outset. So there's a point of principle.
Yeah, I understand that. My point's a different one, is it?
Sorry, I apologise.
If he's right on the word mark,
yes,
on 10-1,
yes,
then we don't need to bother with the camel one. If he's wrong on the word mark, he's not going to succeed on the camel one. So why do we need to think about the camel one? The answer is we don't.
You're right, other than formally to say they all fall with the same character that they would not. You're right. It's not going to make a particular difference to the outcome of this. I apologise if I was being slow about that. But it is important because I think my learned friend wants to say that the court made a fundamental error principle. He had a 10-1 infringement, assumed likelihood of confusion, and then we had a huge burden to come along and say there's no evidence of confusion, therefore no likelihood of confusion, despite 10-1 infringement when we come to consider honest recoveries. I think that's the plank he wants to leverage up onto as a result of the 10-1 infringement case. Yeah. Is that in the bundles? So insofar as the concession goes any further, my lord, the paragraph 26 of his opening submission said the brevity of the judge's reasoning. He just said it matters very little. Sorry, I don't need to get that. Sorry. Construction of services. Again, we've addressed this in our skeleton at second skeleton at paragraphs 13 to 21, and then again at 13 to 38.
So, can I begin this topic by asking you two questions? Firstly, what in your submission does the word broker mean in this context? Secondly, was there any evidence at all before the judge as to the consumer understanding of the word broker?
While I take him out of my stride, Lord, I'll ask your questions directly, but then I'll go through what I want to say more fully. Broker, I think, is my submission is slightly red herring in this case. It's used as shorthand by the judge. It's used as shorthand by the parties. But what needs to be determined is, a matter of fact, what was the service or activity that Nuclei was performing under the EasyOffice's mark. And we have a finding of fact.
Well, the judge seemed to regard the term broker and cognate expressions as being important.
Well, it's important because everyone used it, Lord, because it described everyone used it.
Yeah,
but it described two different.
But the question is, what did they mean by that?
Well, I'm going to
it's
show
all
you.
very well saying everybody used the term, but what does it mean?
Well, that's exactly the point I'm going to tell. That's what I was saying. But what it means is, it's a portal service. I'm going to show you that in a moment. What it means, it's a directory or portal service where they stand. The party in Nuclei's shoes stands between a consumer who wishes to use serviced offices, which have been provided by the service office provider, and the service office provider who has those physical premises to rent, hire, provide service accommodation. And I'm cutting right through, but it's effectively an electronic yellow pages service. They are acting as a directory of all the physical premises suppliers and they allow people who are interested in physical premises to be rented or to be hired, go through their portal.
It goes further than that, doesn't it? Because your clients provide quotes.
I'm finished. Let me finish. And they also get paid. The intermediary gets paid if one of the customers then goes and takes the office provision from the office provider. And that's the business model that is made. And you will see from the evidence I'm going to show you, which I had for her, that originally our business model, Nuclei's business model, was on the basis that they were paid effectively as directory listings, that each of the businesses who were offering premises would pay to go on their website. That very rapidly, within months, was a model which they realised was a business failure. So what happened was they started listing all the offices, and that they only got paid, their income came from the office providers if one of the people whom they introduced then entered into a relationship with the office provider.
So that's a business model which is more akin to estate agency. Do I understand correctly?
No, I don't think it is, because estate agency, normally a estate agent acts as an agent for the seller of a property. Here they aren't an agent at all.
But not agent in the strict sense, because of course the contract is concluded between the parties.
Yes, but their obligations are obligations to the landlord.
Yeah.
Whereas that is not the situation here. This is very much more like a Google or a Yellow Pages directory. It's a more neutral one, but the business model is weighted, if you like, in terms of the income comes from the successful transaction between the ultimate consumer on one hand and the office provider on the other, actually entering into an arrangement where the consumer uses an office.
Is it your case that the evidence showed they weren't acting for either party in any real sense?
Yes. And it was a very, very important part of that, because you recall, or you may recall from the judgment, that Nuclei was a totally independent complement setup. It was set up by Abrahams, who was an ex-employee of Regis. Regis was the biggest office supplier in the UK, probably in the world. And he set up as being totally independent of them. Then in 2007, Regis purchased this business. But it was fundamentally important for this business to be successful that the Nuclei business was seen and understood in the marketplace to be totally independent of Regis.
So it lists other people as well?
So, yeah, exactly. So it listed everyone. It always listed everyone. And it wasn't in any way favouring any particular premises provider. That was very important. There was a whole secondary issue, it'll come back pivoty, about who owned all the shares, who had control and whatever, and how the shares came back and forth, to show that it was an independent party. So it was able to act as a middleman, as independently Regis as to any of the other third-party service providers. And so the potential users, customers at the end of the day, could be confident that there's no sort of unlevel playing field in terms of listings of the Regis service offices.
Is there any difference? You've used the word intermediary, you used the word middleman.
We also use the word the introductory, and that these are all words that we used, and I'm going to show the evidence. So the judge shouldn't have just pick a finger out of the air in relation to this. You've been given a couple of snapshots and a couple of pages of a website. There's a whole mass of evidence about how people actually described this business, including from Mr. Abrahams, including from how it was published in business journals in 2001, before they started, and cross-examination of Mr. Abrahams. And she cobbled that together, and she used as a shorthand broker, because that's what the parties had actually been using in their pleadings and in their own evidence, by dividing up the business in two different ways. But also, she used the word portal and so forth. And I can show you the judgment.
Nuclei doesn't just list properties that are available for offices, does it?
It goes beyond that.
It must have agreements. It must have agreements with the landlords, that the landlords agree to being listed. Otherwise, how do you secure your payment when they enter into an agreement?
My lord is logically correct. There's no evidence in relation to that.
No evidence at all in
Not
relation to
that I
the
can,
method
not
of
that I
doing
can make
business.
it at all. I'll get my learned junior who's much more diligent than I am and more capable of searching. But I don't recollect there being any evidence in relation to that. But I'll show you what I was going to show you what the evidence was in terms of the business model from Mr. Appellant, which the judge had in a few moments. So I can make good the submission I'm making now to you as to what was perceived to be covered under the term broker.
Because, I mean, if one's right to infer that there must have been some sort of agreement, it's not very different from an agency, is it? In the sense that they agree that you list it and they agree to pay you if they sell it, if they sell the space.
Well, it's different. I wouldn't accept that. It's much more akin to a Yellow Pages directory type position. Now,
But Yellow Pages, they only get paid for the insertion of the advertisement. It's as simple as that. This is a completely different
this
model.
is the electronic. So you're a lot of the electronic Yellow Pages will get a sort of click-through payment. Now, there have to be some underlying agreement in order to accept for that payment to arise. What I can't tell you is whether there was any specific evidence in this case. I don't think there was what the relationship was between the landlord and any of the brokers, whether that's instant offices or whether it was Nuclei or whatever.
The case seems to be characterised by huge gaps in the evidence on both sides.
So what I was going to do then was show you the judge's material findings as to what Nuclei did, and that starts, I think, in the judgment at the substantive bit is 299 of the judgment. Just again for your notes, she had made some earlier references, general comment. Let me take you all the way through the whole lot, so you see everything in totality of what she's said in relation to its business. So pick it up at 9, paragraph 9. So she says here, the first defendant interested in UK business was activities in online advertising or brokerage of serviced offices, office space and related services, set up by Jonathan Abrahams. Then at 23, she records that in 1999, Mr. Abrahams left his job as a sales manager at Regis to pursue a business venture which involved using the internet to broker the rental.
I'm sorry, where are you now?
Sorry, paragraph 23. Sorry, did I say 29? I do apologise. Paragraph 23.
Thank you.
I'm sorry. First sentence. In 1999, Mr. Abrahams left his job as sales manager of Regis to pursue a business venture which involved using the internet to broker the rental of service offices. Then she makes at 190 for the reference. That was 190. By that point, Nuclei had been trading as EasyOffices for around 13 years. Since the spring of 2000, its revenue had gone up from modest beginnings to turnover to 1.37 million turnover in the year ending December 2007. In the year ending December 2013, its total turnover was 852,000. But already by 2002, after its first few years of trading, Nuclei's clients included many of the largest suppliers of serviced office space in the UK, including Regis itself. Their office space was advertised and supplied by Nuclei via the www.easyoffices.com website under the mark.
So that seems to be a finding that Nuclei supplied office space.
No, let me get to the findings. I'm giving you everything she's recorded, and then I'm going to get to the findings. Then
What do you submit that last sentence means? Their office space was advertised and supplied by Nuclei.
Yeah, but that is not the full finding of what you find Nuclei to be. It's not intending to be that Nuclei themselves were supplying office space, because that's not what she finds. She draws a complete distinction in relation to that. I'm showing you everything so that you can then see the context in which she then makes her actual finding, which is 299. and then 301. The Nuclei EasyOffices business does not however fall within specifications of the 528 and 509 marks. Closest specifications come to Nuclei's business are the specifications for the hire or rent of temporary office space. Nuclei does not, however, itself hire or rent office space, rather acts as a broker for the rental of serviced offices, providing search facilities for potential customers to find office rentals provided by the companies listed on Nuclei's website. And you go down then to 301. The same is true of services as the case. Service considered brokerage of service offices not ancillary feature of the rental office space itself, but different service entirely. Mr. Manlich argued anyone visiting at the EasyOffices website will understand that this was a service of office rental. I disagree. While the EasyOffices site advertises offices to rent, nothing on the website indicates that EasyOffices itself rents or hires offices. Quite the contrary. The website makes clear that it's a portal to enable people to find office space. That is emphasised by the information given under the heading About Us. We created EasyOffices for one simple reason, to make it easier for people to find great places to work, to gather every square foot of workplace and put you under one roof. And that picks up the point that my Lord Justice Nugee was putting to my learned friend. When you see the website itself, you fully understand what EasyOffices sign is being used in relation to. You don't see a little snapshot, you see the whole website. When you look at the whole website, you understand what it's doing. What it's doing is not itself, it's not Nuclei using the badge EasyOffices as a badge of origin to indicate that it's renting or hiring offices to rent. Rather, it's acting as a portal to enable other people to find office space from third parties who are themselves renting or hiring offices. Taken together, we say that is a finding of fact which she was entitled to come to, and in fact one that she should have come to on the basis of the materials before her. And I'm going to show you the materials that she had before her to make that good, if I've got time.
Does that mean that when, in paragraph 190, she does appear to say that Nuclei advertised and supplied,
it's a shorthand.
It's a shorthand for what
the more fuller explanation she's setting out in 299 and 301. Just trying to explain what it is. Yeah. And it would be very unfair for the judge to have her judgment passed in a way to see that she's mixed one thing, suggesting one thing at one stage and another. We've got to read the totality. And we say that read fairly to the judge in its totality is a finding of fact, specific finding of fact, of what the EasyOffices website was doing, how it would be perceived, and the way in which the EasyOffices sign was being used in relation to the EasyOffices website. It was a portal service, and on the back of that, the judge was right to find that was an identical service within the 376 mark division, but a different, similar service.
Is it your submission that the judge has applied the test of the perception of the average consumer here?
Yes, and again,
where does she do that?
Again, Lord, with great respect to my learned friend, we had a long section in our open submissions about average consumer, about being highly sophisticated in the nature of the average consumer and how it's going to be dealt with. It wasn't addressed at all by the other side. And again, with the greatest sympathy for the judge, it's our respectful submission that she assumed, therefore, that was something that was taken on board as a forgiven, and she was analysing it on that basis. You can't find it. You can't find it in the judgment. You can't find a detailed analysis of who the average consumer is. It's not dealt with at all in the judgment. Nor can you find in the judgment her clear and unambiguous statement saying that when she's analysing the EasyOffice website as to what it is, that's the perception that the average consumer would have of it. But that is the context in which she is making this judgment.
Was there evidence as to who the average consumers were? These were SMEs,
yes, well, there was evidence, and I'll show you what is in terms of the business model. So you had in terms of the customers of Nuclei, in terms of the service providers, you had all the office service providers in the country and some around the world, everyone from the largest regions to someone who had maybe some small spaces. And then you had some evidence of who could be using it. But it could be anyone under the sun who would come in and say, I want a short period, or I want something for 2 years or whatever. So on the one hand, the ultimate customer, the person who's going to come in off the street to use it, could range from being a business person who wants some office space to another large corporate entity who wants to take office space for 2 years or whatever it is, whether it is New York or London or Paris. But the other side was always business to business. So the other customer to Nuclei and EasyOffice is always the business, i.e. the business who has the physical premises to allow it to be rented or to be hired. And that's one of the things which I say the judge fully got on board and wasn't fairly put to you as to why this is clearly a materially different service than the rental of office service. Because when you think about rental of office, the customer of that service is the person who comes in and wants to rent the office. The customer of the Nuclei service are two different types of people. You both have the person who rents the office and also you have the person who's looking for an office to rent. Both of them are people to whom the mark is addressed. And that's therefore inherently, when you think about the analysis going on there, inherently a different service that's being provided in those circumstances than the one which is just simply providing the office space.
The websites we were showing
Yes.
look as if they're addressed to what you can call the consumer, the person who wants the space.
Yes, I think that's probably fair.
Yes, they say we collect together
Exactly.
office space
Yes.
and
Yeah.
you can find it.
Yeah.
They're not addressed to the landlords. The websites don't seem to be. Presumably there was some other means of marketing Nuclei's services to the people who were going to be asked to pay to have their properties listed. Well, pay if a listing
If
resulted in
a successful transaction.
Yes. Was it,
I can't help you with that.
there wasn't any evidence.
There wasn't any evidence.
I mean, you might have had a website which said, if you're a landlord,
Yes.
click here and
Come
this
here
is
and
what we
join.
can do for you. But it doesn't.
Sure.
What we were shown doesn't seem to say that.
No. I think that's a fair comment in terms of the evidence for the judge in terms of the EasyOffice's website. I think that's correct. Yes. Okay. No, I was actually jumping ahead. So what I was going to do was in relation to, before I show you the evidence, I'm just going to address the 4 points I think my learned friend formally took, partly orally and partly in writing, about his construction argument per se, namely that rental of office space or hire office space is a all-encompassing service which includes the service. In fact, the judge found that Nuclei was conducting, because I think he still held, despite prompting from the bench, that he was making a submission that rental or hire of office space is identical to the portal provision. Before we even get on to advertising, and we say that's wrong for at least 4 reasons that he relies on. Firstly, he relies on, as a matter of plain English, that the nature of the services of rental of hire office space are wide enough to cover the portal usage. We say no. You just have to ask yourself the question of considering the portal service provided by Nuclei, is that within the core meaning of hiring or renting of offices? And the answer is, we say, no, the core act is materially different. One is providing a service office to a consumer. The service provider is giving access to physical premises to a customer who wishes to use those offices typically for a fixed period or on a temporary basis. Where the nuclei service is materially different. It's providing a directory or advertising portal to allow the service office providers to advertise their offices' availability and potential customers to find these offices. Intermediation service helps office providers fill their space by referring inquiries to them and advising the customer. It's essentially a facilitation role. The average consumers are not the same, but include different class of people. And I'll just describe that to you in my lords. My learned friend floated the prospect of, as I understand it, testing whether or not these services were the same by applying the canon criteria and criticising the judge for not using the canon criteria. Well, it wasn't submitted she should do so, but if the canon criteria had been applied to these different services, the court would have found them to be similar but different. Canon criteria are often assessed when you come to consider whether services are similar in the likelihood of confusion test, my lord, to assess whether or not what is the nature of the service that is being conducted, what is the intended purpose, what's the method of use, are they complementary or are they in competition, etc. And one event sort of suggests that was something the judge should have done, but she'd already done that as a matter of plain language by considering the nature of the service being materially different, such that they stopped being identical. My learned friend then said that the law supported, in writing, the law supported a wider construction, and he on this point, he just took you to UView, which is my Lord Justice Floyd's judgment, that for the proposition that when one construes a specification, service specification, one should not strive to give an unnaturally narrow meaning. We'll accept that as a proposition of law, Power 13 of that judgment. But what he didn't do is balance that with obviously what is the standard starting point, which is endorsed, which was initially ventilated by Mr. Justice Jacob in Avnet, and then endorsed by him as Court of Appeal in Reed. That specification for services should be scrutinised carefully, should not be given wide construction covering a vast range of activities, and should be confined to the substance or the core of possible meanings. Of course, my lords, Lord Justice Arnold and Lord Justice Floyd, have been looking at it, looked at that again in Sky Kick as to whether or not something falls within a particular service or not. So you do look at what the core of the essence of what the words cover, rather than trying to strive something which is wider. My learned friend relied this morning on some documents from NICE classification. I don't think I need to take you back to them, but they're in your notes. They're in the Authorities Bundle 6, tab 79, page 1803, and they've put in some new ones this morning from page 1829. And obviously one just needs to be careful about what that's showing. That does not show, even under the NICE classification, that brokerage of services falls within a subclass of rental of office space, even in the NICE classification. But even if it did, it's not a relevant document, because what they're trying to do is rely on that document as an aid to legal construction. But what in fact they're doing is trying to leave that document as evidence of what the average consumer would perceive the nature of office rental services to be, compared with brokerage, which doesn't really help this court at all, because what the court needs to look at is actually what the services that Nuclei are performing, and under the term or label brokerage, is that something which falls within the scope of the construction of rental of office space. They weren't documents put before the court of first instance. They aren't documents which are current at the date of assessment infringement of 2013, but they're later. and we say therefore they are not actually material to this decision making at all, and they weren't before the judge. Then as to the evidence, my lord, my learned friend says he got some cross-examination as to Abraham's, which is suggested as a purported omission, that properly construed rental or hire serviced offices must cover what Nuclei did. And in relation to that, I say I've got 4 points in relation to that. One is, as a matter of principle, a witness's subjective opinion is not evidence of the proper construction of the service which is registered, nor admission of parties is providing services within that registered office. It's neither probative nor determinative. Rather, the judge had to ask herself, as a practical matter, what is the core service covered by the term, and as a matter of fact, what was the service that was in fact provided by Nuclei under the EasyOffice's sign on the website. Secondly,
well, is it not relevant to consumer perception? I mean, I can quite understand a submission that insofar as a specification of a trademark is a legal document, it's not for witnesses to interpret it. That I can understand, but I thought you'd accepted that here we're concerned with questions of consumer perception.
yes, I am. But what he tried writing is something like probative of it. I'm saying it has some. You can give it some weight. You could give it some weight. What I'm actually going to say when you come to it, the material point of this is that the weight that could be given to it has to be in the context of what actually the cross-examination elicited. And that was in the context of the cross-examination previously, teeing up these questions, was that Nuclei was a broker sitting between the customer and the person providing the office space. Nuclei were providing a service for their business customers, both the physical property provider as well as a potential user for physical property. And so somehow to suggest actually all they were simply doing was providing, admitting that they were providing rental of or hire office space was a misleading partial quotation of the totality of the evidence that Mr. Abrams had given. I was going to show you both the initial part of the cross-examination and also his witness statement, where he addresses what actually he described the Nuclei business to be. And what I fear is this classic island hopping, where my learned friends come for this court, found one little extract, says, have a look at this, that's a clear, unambiguous admission, and you can put some weight on that. And the judge actually had the totality of Mr. Abraham's evidence, which actually was not that we are somehow the same as providers of serviced office space. We were in fact a portal provider. So the two bits of evidence I was going to show you, and then perhaps that may be a convenient moment, my lords will no doubt tell me. Cross-examination, that's in Supplemental Bundle 1, tab 37. Page 308 of the bundle. And if we can pick it up in the manuscript, page 421 at line 7, and this is just following a question by Ms. Mallanch asking about the number of customers, or the nature of the customers that Nuclei had, and Mr. Abraham says a customer, as in someone selling office space, yes, signed up, or a customer looking for office space, signed up to the site, August 2000, yes, and my first customer, I can't remember the date. So he treats customers both being the person selling office space and also the one looking for office space. And then the question goes on, all right, then because you actually put in invoices, we can see, and so forth. This is your document, I think. Yes, this is a set of what we call customer introductions. This is where we are getting paid a fee from the office space company for cut and broken and cut. Right, you can invoice them at that point. Once the deal has been done, then we invoice at that point. Right, so you have customers for sure by the end of 2000, the customer by November 2000. So before that time is around that time we set out to invoice. Just to clarify, so the office space operator, i.e. Regis, does not pay us to list on the site. It's only when we introduce a customer to that company that they pay a percentage of that office deal. I think it's worth highlighting that the original business plan for Easy Offices was to charge business centres to list on the site. That did not go well, I think we say. I think that's fair. You're getting customers on that basis. We got people they wanted to list, but obviously on their free. the free month. I think we've got a few, but not enough, as you know, to be a sustainable business. I think that I've talked about it in my witness statement. We were advised by operators, why do you not just go down the standard route of charging 10% and then we will list our property, because it's a no-win, no-fee situation. Standard route. Standard then, 20 years ago, was 10%. Standard today is still 10%. Is that it basically? Pretty standard. Everyone charged 10%, subject to special deals and so on. It's a standard and it can change. Some operators offer more. For example, they have a new business centre, or not much. And with not much, with a loss of space, they might encourage brokers, agents to push their space and will give you 15%. We will give you 12%, but I think it's safe to say a standard 10%. You say over time, you'd probably settle at 10%. It really is, even if people are paying 15, 20 or % over 20 years, you would still find a median of 10%. Another issue at that stage, you haven't suggested you were one of the few businesses who'd gone online at that stage. There were other businesses, let us be honest, but perhaps it's the market, you were one of the earliest businesses online. So who are you comparing yourself to when you say standard route? At that time, as a true online business with a website, there was us, there was a company called Global Office Search, and coincidentally there were two sales managers that left Regis at pretty much the same time, unbelievably setting up two, not in the same business. Then another company popped up called Flexi Offices. It was an odd time, because within 6 months probably there were 5 or 6, maybe my wonderful idea, all of a sudden I don't know if it's the right exposition, it all came out of the woodwork, and then people get ideas independently from each other or not. They can copy what we have done, but I think it was just a time, the dot-com time, when everyone could have done anything, set up a website and tried to make money from it. Right. We talk about instant offices sending out faxes or something as well. Do you regard them as a comparator at that stage? I've mentioned my witness when I was sales manager at Regis, two companies I dealt with were instant offices and a company called SOS, which is Search Office Space. They were sending out faxes. I can picture my desk with hundreds of faxes of people looking for office space. So that is the evidence which he was giving about the nature of the business and how he described it at that stage. And in his witness statement, in the same bundle SB1, tab 20, paragraph 24, as I note below, the EasyOffice website went live, so this is page 156, went live in spring of 2000. From the day EasyOffice launched until today, there have been two constants. First, we always have the username, the EasyOffice, our trading name, regards to the formal name of the company. Second, we've been in the business offering service office and flexible office solutions using a broker model. In other words, we match up suppliers of office space with potential users of office space. We do not own any office space ourselves. And 35 at page 158, he says, by around August 2000, it's clear that our subscription model was not sufficiently attractive to potential clients, and we need to change our approach. Although we were developing a presence in the market via the website, and although our marketing initiatives, which I discussed below, it was becoming clear that prospective clients were hesitant to commit to a subscription without any guarantee of generating business. I remember being advised, so these clients were obviously the service, office, physical premises providers. I remember being advised by various people at the time, including my old boss at Regis, that a commission-based model was more common amongst brokers, typically raised 10% the first year, dropped the subscription approach and moved to commission model in August 2000. Our first commission-based deal was 8th of August 2000 for an appellant called Change Limited, who we introduced to Astral Estates. Our commission on that deal was £25.85. No bank check, phone check remains hanging in EasyOffices. Offices, 36. This move to commission-based model was game-changing. It's why our revenue shot up. EasyOffices has continued to use this commission-based model to this day. Could you just also look at 38 briefly, if you would, please, my lords? Giving the nature of the customers and so forth. And I'm very helpfully provided with a note by those around me that the website and you give an example at SB1, tab 23, page 253, has a little space, which obviously under the EasyOffice's name, register your workspace, link in the footer, address to the office provider. So pick up my Lord Justice Nugee's point, and hopefully addressing in part, but not any more substance about the agreement, Lord Justice Christopher Floyd's point. They do use the website to advertise.
Can you give that reference?
Yes, SB1, tab 23, page 253. It's fair to say I don't recollect that being something that was specifically taken, the judge was specifically taken to that point at the trial. But as a matter of fact, the website's very clear that it's used to advertise to other service providers. I was going to show you then, before I leave the evidence, 3 further bits of evidence about how third parties considered the use of the brokerage model to be materially different from the use of providing offices for rental. The first is from Mr. Anthony Rob John, the Managing Director of the Claimant, or EasyGroup, in 2008. That's also in the SB1 bundle, and that's at tab 35. And this is an email as at February 2008, at a point at which EasyOffice, the EasyGroup company, had just started to trade, and there were discussions at that point between EasyGroup and Regis about the possibility of some deal which they might be able to do. And if you pick it up at paragraph 3 next, we come to the branding, and here I think I need to recap in the sense that while it could theoretically be possible to keep the EasyOffice and EasyOffice's brands alongside each other for sites and brokerage respectively, I just think that's confusing, don't you? I know Nuclei will say that they've built up a reputation that won't mix with our brand, but there must be a way to have a communication strategy so one is migrated, or the brokerage is migrated to a new name. I need to understand the sticking points a little bit more. So that was EasyGroup themselves, considering that what they were providing as the EasyOffice sites was different from the brokerage business. And then we have at tab 17 of the same bundle, we have an earlier witness statement of Stelios. It's maybe from W3, but certainly from 2017. I'll check where it is, but the point I want to pick up is 196197, where he said EasyOffice also offered a booking facility under EasyMark Office for more than 4,000 service offices of third parties throughout the world. This brokerage service has been in operation since around June 2007. Both EasyOffice's serviced offices and the brokerage service was operated from easyoffice.co.uk. 197, a voluntary notice of appointment of a liquidator was filed at Companies House in July 2012. Since the winding up, EasyOffice has not rented serviced offices, but the website has continued to operate, offering a brokerage service via an online booking facility of serviced offices owned by third parties. The screen print of the website as of 22nd of September 2015 shows this. It is W3, it's from W3. And my Lord Justice Arnold may have a vague recollection of that. But of course that's quite material when one comes to consider the evidence the judge had before her as to whether there was genuine use in Croydon after July 2012. And the third and final document is a third-party publication called the British Location Review from 2001, and that's in tab 22, page 168 of the bundle. And you'll see the first page, the volume 19, issue 304, 2001. Next page, page 169, EasyOffices.com being advertised, EasyOffices name being advertised at the bottom. And there appears to be something like an advertorial. I can't tell whether it's actually an advertorial or someone who's very badly copied a press release and not changed the relevant words. But you'll see that the description here, which is obviously well before EasyGroup had even filed a trademark, let alone even used a trademark for EasyOffice. So there's no suggestion, there's no possible thought there could be any dispute at this stage describing what the EasyOffice's business is. And rather than me wittering, could I leave it to you?
And in your submission, suppose someone just looks at the advertisement as opposed to the advertorial above. What's the message conveyed by the advertisement? Flexible offices, serviced offices, virtual offices.
But that's not what was claimed to be an infringement, my lord. What was claimed to be an infringement was the website.
Understood.
The website, and this is an infringement case, the website from 2013, which has been the business model which they want us to stop using.
Well, I'm sorry, Mr. Bannigan, either this evidence is relevant or it's irrelevant. Which is it?
No, my lord. No, that's two different points you're putting to me. The evidence of what the nature of the business is, if you read the totality of this, you will find out the person reading the advert and reading the text will know exactly what EasyOffices is doing, which is not providing rental of offices. It's providing a search and introduction system. So the simple answer is, the person who reads the totality knows that this isn't an advert offering the rental of office space. But the material question, my lord, I respectfully submit, should have put to me in terms of the infringement cases, whether there's been any use of the EasyOffices sign since 2013 on the infringement case, which would have given rise to a question that they were using it in anything other than the portal sense. And I say the judge has had that material for her, and she came to the finding that they were using it only in relation to a portal sense and not in relation to rental of office space per se, and she was entitled to come to that conclusion.
So, do I understand from that submission that you would accept there is a distinction to be made between, on the one hand, the question which I think you've submitted is a pure question of fact, namely, what service was Nuclei providing during the relevant period? And as to that, you say it's unchanged since 2001. It's always been the portal, whatever you want to call it.
Yes.
But then there's a separate question, which is focusing upon the use complained of 2013 onwards. Is that a use of the sign in relation to something that falls within the specification?
Yes, and obviously I say it does fall within the specification of 376, it's an information type service, but it's not within the specification of 528 or 509, which is the rental of offices. Because when you look at the actual, the context of the use, eventually you've got to look at the context in which the sign is used. What is that sign being used in relation to?
But your submission is that the answer to question 2 is dictated by the answer to question 1.
Well, not dictated, Mark, but obviously it's a mixed question of fact and law, because you've got to have in mind, when you ask yourself about as a matter of fact what's going on, you ask yourself as a matter of fact what Nuclei are doing, and then there's a question of mixed fact and law. You ask yourself, is that service something which falls within the scope of the proper construction of the specification? And there are two elements here, really, that I think need to be detached a little bit. One is what is actually just the core service that has been provided by Nuclei. And the core service is quite similar as a portal. There's a second ancillary point floating around here, which my learned friend was trying to dangle in front of you, which is saying, no matter that being the core service, actually when you look at the website, here's a little instance where they're clearly being understood to be advertising offices for rental, and therefore it's advertising use. And we say, no, it's not advertising use of the service rental of offices. It's an advertising service or an information service which allows third parties to advertise their offices on that rental, on that portal. And that the average consumer looking at that portal would understand the material difference between the use. It's just like Yellow Pages or Google having their banner there. Underlying it, you've got Regis offering rental offices for rental, physical premises for rental. The average consumer understands the EasyOffices mark is not designating, not a badge of origin, not any sort of guarantee in relation to the underlying office space. but it's a directory service which allows the consumer to see what office space is available.
All right, well, I think we've
Is that
got
an
to pause
inconvenient
there.
moment or convenient?
So, how are you doing time-wise?
I will definitely finish tomorrow. I hope to finish quite early tomorrow. I've got
Yes, but then there's a lot of other issues.
there are a lot of other issues. But by finishing tomorrow, I'll also have done consent as well. So we will definitely got through consent. My lawyer will reply by the end of tomorrow. At the very minimum, we may even be getting on to some of the respondents.
All right. 10:30 tomorrow.